All right, so as expected, the decision to grant former President Jacob Zuma early release has sparked a charged debate about the rule of law in this country and whether, in fact, it's being applied fairly. According to Justice Minister Ronald Lamola, Zuma was released from prison yesterday in terms of a remission of non-violent offenders that was approved by President Cyril Ramaphosa. Let's unpack this for you now. Bring in legal analyst Melusi Xulu, who joins us via our video link for more, at least on his thoughts. Great to have you on the program, sir. Thanks as always for making time to help us connect the dots, as it were. The point that has been made since this announcement was made is that, in fact, the president, the incumbent, is empowered by the Constitution. I think it's section 84(2)J, allowing him to essentially make such pronouncements, to cut a long story short. And despite that, we're still hearing murmurings, for instance, of parties like the DA who are now considering their legal options to see if, in fact, they can challenge this. Can you think of any possible channel through which this can be challenged in a context where the Constitution is so clear?
Good morning, Ayanda, and the viewers at home. The Constitution is very clear, Ayanda, as stated in Section 84, subsection 2, paragraph J. It empowers the President to pardon or reprieve offenders and also to, remit any offences or penalties. So there is a constitutional right that the President has. And it's not the first time, Ayanda. In 2012, the former President also did a remission for 45,033 prisoners. In 2005, former President Bey also did a remission for 65,387 prisoners. So it's not a new thing. It's just that it coincided with the President's release. But we will see how they can constitutionally challenge it, because it's a constitutional right that the President has.
Can it be challenged on the basis of rationality, challenging whether or not it stands that test? Because, interestingly enough, News24 released an article this morning, I think it was, where through their own digging, ironically, they were able to find that Escort Correctional Services actually has 3 empty beds at the time of the former president's release. So if it was a capacity issue, it certainly didn't affect the institution where he should have been incarcerated.
Okay, let us remember this. The special remission is not only about overcrowding or dilapidation, as they say. It's also focused on low-risk offenders. So let us ask ourselves this: is the President a high-risk offender or is a low-risk offender? And if he's a low-risk offender, he's entitled to that. And I think, we should look at our sense of Ubuntu at the same time. We are talking about an 81-year-old man, and a very old case which still applies today, as versus in 1969. It was an old apartheid case, but it applies to everyone, black and white. They say there are 3 things we should look at. We should look at when we're sentencing a prisoner, we should look at the circumstances of the prisoner. We should look at the interest of the society. We should look at the seriousness of the offense. So here we're talking about an 81-year-old man, and he served his time in prison. He served his time, although it was an unlawful medical parole, but he was still restricted during the medical parole, so he can't be punished for something that was decided by the state.
Sure. And there's been a lot said about how we actually even got here. I wonder whether you reckon that debate has also been put to bed. This idea that the former president himself, in fact, shouldn't have been incarcerated by the Constitutional Court when it found him guilty of being in contempt of court. A lot of the former president's own supporters haven't moved on from that part, arguing that, in fact, that's where things began going horribly wrong.
Let us go back to history a bit. In 1990, when there was a Truth and Reconciliation Commission, the former president during the apartheid era, P.W. Botha, was told to come to court, was summoned to come to the commission. He didn't come, and what happened was there was a trial held on contempt of court, and then he was sentenced and he paid a fine. I don't know if there was an imprisonment suspended. In the case of Zuma or the former president, Msholozi, there was no trial that was held. If you can go for as versus Zuma in 2021 for such a contempt of court trial, you will not find it. So it was a very bizarre, strange decision that was made. It was very unique, and that is why there's a school of thought that says maybe there are Zuma laws, but At this stage, obviously, we're not talking about that case, but it's something worth noting that there's a difference of opinion on that. So it was a very strange thing for some others, especially the supporters of the former president.
Yeah, but I think it's still worth going back there because perhaps there are many lessons to be learned, right? Is it not enough that the Constitutional Court, in fact, acknowledged that it was doing things differently? I think the former president was described as a recalcitrant litigant who has shown multiple times that he's not willing to engage with the processes of the court. I think it was Sisi Gampepe who was reading out that judgment. Part of what she also mentioned is that the court has, in fact, tried reaching out to the former president on multiple occasions, and he's made it very clear that he wouldn't cooperate. Does that reasoning, is that not enough?
Well, I think I'll be direct on this one. Personally, I'm with the minority judgment on this one, where they say that, the procedure is that when there's a contempt of court, the docket obviously should be open, and then the matter should be taken to the district courts, not just go to the constitutional court. So that is the procedure that is expected. That is why I went back to the archives and I spoke about the P.W. Botha case, because what happened was he was charged. And so that was what was expected. But it's just that on this case, there was a different approach. And I don't know if that is how the approach will be in the future. And we are here today because of that.
Sure. The former public protector, Thuli Madonsela, has also weighed in on this. He reckons the point has now been made. The former president was sent to jail. He did spend, I think it was 2 months in jail. And this idea that, he is above the rule of law certainly isn't as prevalent as initially it was. To what extent do you agree with her?
Well, what I read a bit, I know there were so many people who were not happy with the comment, especially those who don't support the former president. But what I read into what she said, she spoke about the principle of Ubuntu. And I think that is what I was highlighting when I spoke about S versus Zin. S versus Rabi 1975 also highlights that a crime should fit the criminal and the crime. Sorry, a punishment should fit the criminal and the crime. And it should be fair to the society. And there should be a measure of mercy that is given to the accused as well. So with what I've seen is that most of the people who are not happy with this particular decision, you don't sense any form of mercy given to the president. He's an old man. He served his time. Whether the medical parole was unlawful, but he was restricted during this time. So what more should be done? Because, if we are to test our society, we should test how we treat people we don't like. If there's someone that you don't like, that person still deserves justice as well. And that's my take on this.
I hear you, but I suppose the challenge now for the state is to make sure that they're consistent, right? If we are as magnanimous as this ruling or this remission suggests perhaps we are, the challenge now is to make sure that if there is in future another 80-year-old who's arrested for a minor crime, they too should be afforded this kind of reprieve.
Well, if you go to courts, these are one of the arguments we make if we represent all the people. There is that certain, kindness towards them, obviously because of their age. Not that they shouldn't be punished. I must highlight that. But there's a different approach when it comes to all the people because, the system in prison, the way, people stay in prison is not obviously a better position for all the people. So I'm not saying that they should always be given favor, but, we just have to approach it a little bit different. That's all I'm trying to highlight on this when it comes to all the people. Yeah,
it almost feels like the back and forth, at least around this particular legal challenge involving the former president, is coming to a close. And I wonder, given the line of work that you're involved in, what you reckon the big takeaway is when it comes to jurisprudence and other legal lessons to be learned around how, in fact, this matter was handled?
I think what matters, like you said, we can go back to the Constitutional Court, but I think what was important on this matter is the issue of medical parole. If you go to Section 79 of the Correctional Services Act, the 1998 Act, it talks about the fact that when a medical parole is given, is given on the written submissions of the medical practitioners. Maybe it's a lesson that when the commissioner allows for a medical parole to be done, they must just make sure that they use the expertise of the medical experts or medical practitioners so that these court challenges are avoided in future. That's my take on the medical parole aspect.
Right, Melusi Xulu is a legal analyst. Sir, thanks very much indeed for your time. Our conversation ends here, but I have no doubt the reaction doesn't, and we'll keep watching the story as it continues to unfold. Once again, Melusi, thanks very much indeed.